Has anyone been placing any bets on whether or not these DMCA cases can get any stupider? If any of you have bet that there's no possible way they can sink lower than they have before, you're gonna have to pay up. Cause now we have Emmerich Newspapers v. Google. Now this isn't an AI case, but it is a DMCA case with a lot in common of the cases that we've seen before. This is in particular going to be about the CMI. And this is a case against Google News, not Google's AI. And they're saying that was copyright infringement by using their images and clips for Google News and Google News searches. Just doing that much is infringement. But also it's infringement because they stripped the CMI, and this is where it's going to get silly. So Google has had a couple things to say about this. One is that this is in the Southern District of Mississippi. Yeah. Google wants it moved over to the Northern District of California, where they are, because they say by their terms of service you agree to that, and also the Constitution says you have the right to be tried in the district where you were when you committed whatever it was you allegedly committed. But this one is about them trying to get Count 2, just go ahead and get that out of here, because it's dumb. Count 2 is the CMI. And so we have their reply in support of their motion to dismiss Count 2 of the complaint. So what's happened is Emmerich issued a complaint. Google moved to dismiss Count 2 of that complaint. Emmerich responded to that, and now Google gets to reply to the response. For some reason, they never posted the original motion to dismiss or Emmerich's response, but we've got Google's reply, and that's going to be enough for us to see how massively stupid this is. So let's get into it. Emmerich devotes much of its opposition to arguments that Google has not made, and it's talking about what they did in their response, which Google is now replying to. In particular, it defends its copyright infringement claim, even though Google expressly stated it was not challenging that claim at this stage. My guess is they're going to want to get it moved over to the Northern District of California first, and then challenge it there. What Emmerich does not do is overcome the dispositive flaws in its separate claim that Google removed CMI from its photos. Emmerich has not plausibly alleged that Google actually removed any CMI from Emmerich's images, and Emmerich has not and cannot allege that Google acted with knowledge. They misrepresent the federal pleading standard to gloss over a more likely and entirely benign explanation for the appearance of its images on Google News without CMI. Check this part out. That Emmerich makes its images publicly available in a separate location on its websites with no CMI at all. So they just put the images up on their website. Google does what Google does, takes the images, and now they're suing. It was Emmerich's burden in filing its complaint to plead facts that, if true, allow the court to draw the reasonable inference that the defendant is liable for the misconduct alleged and to rule out obvious alternative explanations for the defendant's conduct. Emmerich failed to satisfy Twombly's basic pleading requirement, and no amount of hand-waving can fix that failing. By itself, that dooms the claim. So if they posted their images without CMI, Google grabbed those to put into Google News, there's nothing here. And Emmerich misrepresents the law. It argues that Emmerich need only allege intentional removal of CMI and can ignore the second Scienter requirement that Google undertook any such removal with the required knowledge that its conduct would induce, enable, facilitate, or conceal copyright infringement. Emmerich has pleaded no facts at all on that point and offers nothing in opposition to justify its failure. Again, opposition meaning their response to Google's motion to dismiss. They responded with an opposition brief, and that's what Google is replying to now. So that was Emmerich responding directly to what Google claimed. The law forecloses the claim that Google had the requisite Scienter. Google News prominently displays the source of Emmerich's images and links back to Emmerich's websites where additional attribution text is readily available. Emmerich's opposition does not begin to address this dispositive Scienter issue. Scienter just meaning they knew they were doing it. But if they are just mechanically, algorithmically grabbing images from a site where they posted them, then where's the Scienter? Where's the knowledge? Where's the intent? Emmerich failed to rule out the obvious alternative, which is straightforward. Google simply obtains the images from a separate, publicly accessible location on Emmerich's websites where they never contained CMI to begin with. Emmerich's opposition concedes this. Emmerich publishes its images in two places, the article URL with CMI and the image URL without CMI. The complaint fails to account for this lawful alternative. Emmerich cannot excuse its pleading failure, instead resorting to mischaracterizing the governing Twombly standard. It repeatedly invokes long overruled cases applying an outdated standard which the Supreme Court rejected nearly 20 years ago. Notably, every Fifth Circuit case that Emmerich cites in its argument for its superannuated pleading standard predated Twombly. Hey, does that sound familiar? Like maybe when Disney said that their argument still stands despite Cox, and all of the cases they cited were pre-Cox? Yeah, these guys are doing the same thing, only with Twombly instead of Cox. The Supreme Court recently underscored its teaching that well-established federal pleading standards require more than a sheer possibility that a defendant has acted unlawfully. Rather, a plaintiff must nudge a claim across the line from conceivable to plausible by pleading facts that rule out obvious alternative explanations for the defendant's conduct. Emmerich has not done so. Crawling the images directly from the image URL, where the images are unmarked by any text, would not entail any CMI removal or implicate the DMCA at all. CMI was never present on the accused copies, so it cannot have been removed or altered. That dooms the DMCA claims. You can't remove what was never there. Grasping to explain why Google would access the photos with CMI and then remove it, rather than simply accessing the same photos without CMI, Emmerich misstates Google's position. It claims Google admits that the image URL is difficult to access because a user must click twice on the image within an article URL to access the image URL. Google's motion said no such thing, and the assertion is false. And anyone who knows HTML knows how that works. You don't need to click on anything. Your algorithm just looks at the HTML, the image links are right in there. Emmerich concedes that the image is always freely available on the public internet at the image URL. Emmerich cannot salvage its claim through misrepresentation. Nor does Emmerich accomplish anything by attacking Google's declarant, because the declarant is not an engineer at Google. As Emmerich surely understands, the declaration simply testifies to the fact that a singular image exists in two places. Again, at the pleading stage, it is Emmerich's burden to plausibly allege that Google crawled the images from the location that actually had the alleged CMI. All Google needed to do, and all that the motion to dismiss and the Willen Declaration did, was point to the obvious alternative explanation. And they tried to invoke Intercept, that is an AI case, to argue that the plausibility standard does not prevent a plaintiff pleading facts alleged upon information and belief where the facts are peculiarly within the possession and control of the defendant. So you see already, they're doing everything they can to do exactly what I said. Take the rulings from the anti-AI cases and move them into cases that have nothing to do with AI, setting those precedents and applying them somewhere else. It's already starting to happen, even though Intercept is still ongoing. But that case is nothing like Emmerich's. They train Gen AI systems on non-publicly accessible data sets that allegedly contain plaintiff's news articles. Rather than argue that there was some obvious alternative explanation for the alleged CMI removal, the defendants argued that the plaintiff's information and belief allegations were implausible on their face. The court disagreed. Here, not only did Google raise an obvious alternative explanation, Emmerich has failed to identify which facts are peculiarly within the possession and control of Google. It is Emmerich that decides where and in what format its images are available online. It can easily consult its own records, such as server logs on whether Google's crawlers access the image URLs, to refute Google's alternative explanation. That Emmerich offers nothing of substance in response is damning. Well, they just want discovery. They just want to say, hey, Judge, let us have all sorts of stuff at Google so we can troll through and see what we find, which is not what you're supposed to do. Finally, Emmerich attempts to rewrite the law in Section 1202B. Under its novel theory, as long as there exists one instance where its images are available alongside CMI, any subsequent display must include that text, even if the images were freely available. Emmerich's position is also at odds with common sense. Consider a photo of an artwork that's on display at a museum alongside a plaque with the artist's name and the work's title, and it's available in the gift shop as a poster without the plaque. If a manufacturer were to reproduce the poster, they would not have removed CMI under any rational understanding of the term. The manufacturer is not obligated to add CMI because a copy of the artwork somewhere else has it. To hold otherwise would impose a duty not only to add CMI, but also to search for all other instantiations of the work that might include CMI elsewhere in the world. That is not the law. As an unbroken line of authority recognizes, and as the statutory language plainly requires, Emmerich must also plead facts showing that Google knew that the supposed CMI removal would induce, enable, facilitate, or conceal copyright infringement. By pretending the second Scienter requirement does not exist, Emmerich implicitly concedes it cannot plead facts to satisfy it. That necessitates dismissal of its Section 1202 claim. And then, like they say in a footnote, the second Scienter requirement was not even at issue in the cases Emmerich cited. It's one of those things that make you wonder if they used an AI. Because we've seen some pretty bad AI fails with the law where they, cite fictitious cases that they just hallucinated. But AIs are getting better, and you can double check that and make sure it's a real case. But here's the problem. An AI finds the case that's right on point with you and says exactly what you want to say. You double check it. That case exists, and it does say that. How do you know that case wasn't then later overruled or in other way altered by a subsequent precedential case? If you're using proper legal research software, they can link you to all that. A regular AI probably isn't going to do that. Emmerich cannot possibly show that Google had the requisite state of mind from what Emmerich pleaded and what is properly before the court on this motion. That means the Section 1202 claim should be dismissed with prejudice. Don't let them refile, Your Honor. Was that dumb enough for you? Where they claimed that they removed CMI on images that didn't have CMI attached to them, and they didn't think, oh, well, maybe they just got it from the image URL. If that's not dumb enough for you, this is dumber. Listen to this. The problem for Emmerich is that it does not and cannot allege that Google passes off anything as its own, where Google includes the name of the Emmerich newspaper that published the photograph and that newspaper's logo directly above the headline of the story containing the photograph, and where clicking on the photograph takes a user directly to the source of the image on an Emmerich website. Because remember, we're talking about Google News here. That's its whole point, is to be a news search engine and aggregator, and it'll show you like, hey, this is in, the Intercept, and then you click and you go there and you read the actual story. By conceding that Google attributes Emmerich's newspapers and links back to them, Emmerich's own allegations preclude any inference that Google acted with the requisite state of mind. How is it that you're going to try to hide CMI in order to do nefarious things if you put it back in? So Google removed none of Emmerich's identifying information. It simply showed a thumbnail of the exact same image Emmerich made available at the image URL without any modification, and in fact added the newspaper's name, logo, and a link to the source article. That does not foster infringement, much less knowingly so. In fact, it does the opposite. It lets people know, hey, these guys did this story. Click on it, you go there. That's like the exact opposite. This is crazy. This is the same kind of thing they're trying to get over in Europe and having more success with because Europe doesn't have freedom of speech. But yeah, it's the exact opposite. Google News is so much a benefit to the news media, but they're greedy. They see, well, we can get money doing this. Let's go get money. Let's sue a big pocket and get money. Accordingly, Emmerich's Section 1202B claim fails. For the foregoing reasons, Google respectfully requests that the court dismiss count 2 of the complaint with prejudice. Knock it out of there, Judge. It doesn't belong here. Oh, and by the way, move it over to our district, the Northern District of California. And I don't know if once it gets there, if they're going to try to pull it under the umbrella of In Re Google, because those are anti-AI cases. This isn't, but you see the similarities. And you see how they're taking those arguments and those tactics and those rulings and trying to apply them to non-AI stuff. So it's not just that it's dumb, and not just that it's dumber, and not just that it's even dumberer. It's about them finally thinking they can do what they always wanted the DMCA to be able to do, which is stop you in your tracks and not give you any sort of fair use rights. Because what Google News does is 100% fair use, which I imagine is what they'll be arguing. And they've already won this with the Google Books case. Count 1 is basically the Google Books case being argued again. This is what we're going to start seeing more of. This is what I warned you about. Those of you who are saying, nah, it'll just stay AI, nah, it won't go anywhere else. Proof positive, right here. So maybe you should listen to me next time. And if you want to keep listening to me, please, comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate.bogosity.tv keeps me doing this. I'm squeezing this in the morning. When I've got a live stream in the afternoon, I don't normally do that. I normally focus on the live stream, but I just had to get this out. You see why. But the more I get from you, the more of this I can do. And it doesn't matter if it's one-time payments or regular support. I get enough in just people sending me just random payments here and there. That does a lot. It doesn't have to be the over and over stuff like on Patreon, Subscribestar, or Discord, but you can go that route if you want and get these videos early and ad-free. Join in the live streams, join in the AMAs. So thank you so very much for watching. Until next time, stay strong and be free.